the second panel of the Scholar Strike teach-ins, which are part of the two-day labor action in defense of academic freedom, against anti-Palestinian racism, against surveillance, policing, and militarization of our campuses. I want to express my immense gratitude to Beverly Bain and the Scholar Strike Canada for their tireless work and efforts putting this together today. And even more immense gratitude to Yasmin, Sarah, Leila, Nadine, and Sarah, who just spoke brilliantly on the previous panel. I think it is the students and the youth who are teaching the world how to live, and they have all of our support and solidarity. My name is Gillian Rogan, and I'll be moderating today's panel discussion, which centers the role of law in the Palestine Solidarity Movement on our campuses and beyond. And I'm really honored to be joined by my esteemed panelists, Sarah Jama, Dania Majid, Rochelle Friesen, Joshua Seeley Harrington, and Shane Martinez. Their bios can be found on the Scholar Strike website, and I'll introduce each panelist in more detail right before they begin their comments. I want to share a message that we received this morning from Acadia for Liberated Palestine. I'm quoting here: sending our support from Acadia for Liberated Palestine to the Scholar Strike Canada organizing group. We have occupied a small space on campus to stream the proceedings and invite others to join. People are gathering now. So wow. All of us here at Scholar Strike are sending our support right back to you all in Acadia, in unceded Mi'kmaq territory. So as a starting point for our conversation, we ground our comments today with the assumption that law is a tool of colonial and imperial oppression. Indigenous people in Canada have for centuries understood and resisted colonial legal regimes that produce genocide, Canadian apartheid policies, and policing. As Robin Maynard reminds us, policing in Canada was born out of colonial expansion and containment policies, as well as slave patrols. Lawfare, or the use of law and legal processes to silence Palestinian voices, has for decades been a tool to silence dissent, to justify apartheid, settler colonization, ethnic cleansing, and genocide. The use of law as a weapon to silence dissent in the diaspora, including in Canada, escalated in the early 2000s when various Israeli government entities strengthened relationships with diasporic pro-Israel lobby groups. This escalation was largely in response to the boycott, sanctions, and divestment movement, a Palestinian-led movement to end Israeli violence. As Hill Akhed has detailed in their book titled Friends of Israel, and I'm quoting here, in 2015, the Israeli Ministry of Strategic Affairs was made responsible for Israel's global campaign against BDS, and it employed more offensive and aggressive strategies, including surveillance, intelligence, and gathering, and black ops. And there's a symbiosis here between the Israeli state as a settler colonial project and the Canadian state as a settler colonial project. They build each other, they constitute each other, and that's what we're fighting against, I hope. In various legal contexts, the heavy hand of law used against Palestinians and those who stand in solidarity largely relies on framing Palestinians as inherently anti-Semitic, including reliance on the International Holocaust Remembrance Alliance definition of anti-Semitism, or the IRA. The IRA is inherently anti-Palestinian and provides an ideological backbone of the manufacturing of consent to genocide. All of our panelists here today have been involved in some aspect of legal proceedings relating to Palestine and Palestine solidarity work, and in some ways have come up against this framing, the IRA framing. IRA named something that was already in existence for many decades, but it just tried to codify that framing. While law, legal processes, and law enforcement have not succeeded in silencing dissent, we nonetheless continue to have to contend with law and the legal system, both in response to legal proceedings initiated against us and as we initiate legal proceedings against others. Understanding law as a tool of colonial and imperial power, but one that we are often forced to engage with, this panel explored some of the recent legal gains and setbacks, strategies, reflections with respect to Palestine and Palestine solidarity activism here. In many ways, the previous panel of students have illuminated these threads already. Law and the violence of law was a thread throughout all of the whole panel, their comments, and we'll build on those comments here as we explore law in slightly different contexts. So with that brief introduction, I'm really honored to introduce our speakers. Each panelist will speak for about 10 minutes, and then if we have time at the end, we'll take some questions. So it's my great pleasure to introduce our first speaker, Sarah Jama. Sarah is a member of provincial parliament for Hamilton Centre. She's my MP, and I'll just say MPP, and I'll just say here that I'm Jewish and I support Sarah Jama, and I've been saying that pretty loudly for a number of years now. And unfortunately, we all have to continue to speak as much as we can to support Sarah, who has been under attack for a long time. Sarah has captured the hearts and minds of the people with her tenacious way of uncompromisingly standing up to power. She does so with integrity and intelligence, even when, and perhaps especially when the stakes are high. In mid-October of 2023, she dared to name Israeli apartheid, Palestine solidarity, and she called for a ceasefire. And she was then censured in the legislature, ousted from the NDP, and she now sits as an independent. So welcome, Sarah. We're so grateful that you took time out of your day to join us.
Thank you for having me. I'm happy to be here today. I'm not a lawyer. I'm not an academic. I am elected, but I'm definitely not the smartest person on this panel, so it's intimidating to go first, but I'm definitely happy to be here. I think some of what I wanted to talk about is what happened leading up to the censure and when I actually got censured and kind of how that connects to the broader fight against censoring that is going on in the broader Palestinian community right now here and the activist community here, and how this fight against the censure is important and connected to all of the work that needs to be done to end the Palestinian, the apartheid, the Israeli apartheid, and the Palestinian, the impact of displacement and genocide going on right now in Palestine. So before deciding to run for office, I was somewhat involved as a student in BDS work on my campus, already doxed by this group called Canary Mission. And throughout the course of campaigning to run for office, Zionist lobby groups, B'nai B'rith, and others were vicious in their attacks to try to make sure that I wasn't able to be seen as electable, that I was seen as anti-Semitic. So that happened before October 7th. And then October 11th, 3 days after the October 7th resistance that occurred that day, I put out a statement calling for a ceasefire, quoting the United Nations, UN Rapporteur on the Palestinian territory. It was a very bare bones statement. It literally said nothing except for the obvious. And I think looking back, when my team and I sat down to write that statement, we didn't expect too much backlash because it was rooted in fact. There was nothing that sort of was made up in it. There was nothing that was overly emotional. But what ensued after that was an 8-hour debate, some of which likened me to terrorist sympathizing, talking about all the reasons why I don't have the right, or Hamilton Center doesn't have the right to be represented in a place of power, for calling for a ceasefire in Palestine. And again, like, that statement was the bare minimum of what could have been asked for. And I think that instance of taking away an entire riding's ability to participate in the democratic process by censuring a newly elected member indefinitely, because I'm still censured, goes to show how strong the Zionist lobby is here in Canada. And it's something that I think I knew, and I was paying attention to all of the other people continuing to get in trouble in their workplaces, in schools, in their legal field, as doctors. Like, that was all happening around the same time. But truthfully, for me personally, I didn't understand the weight of the Zionist lobby until I became elected and until that happened. And seeing groups like CIJA and B'nai B'rith continue to take up space in the Legislative Assembly. They are still present, even to this day. They are still lobbying all members of government and walk the halls. They hosted a reception on October 7th, so quite recently, and continue to be listened to when it comes to legislative and legal decisions that are happening in places of power like Queen's Park. And that's something that I didn't see as an important part of the struggle in terms of the ability to lobby and push back in these ways using these instruments until being elected. They're still very much present. The conversation around Bill 166, the idea that the universities have the right to intervene on campuses with rules and regulations around what they deem to be hate speech or anything else, that legislation is framed by committee meetings where lobby groups like CIJA and B'nai B'rith are present and are actually being asked to testify to the bill and its impact. And you talked about the IHRA definition. Those conversations are happening quite often in that sphere as well, where these groups will come and lobby. Most recently, CIJA, B'nai B'rith, and some other organizations received significant amounts of provincial funding too to continue their education work. Well, we know from what has been released from workers in organizations like this that often what happens is workers are sent in, I don't know if I should say allegedly, to schools to sort of surveil and dox students who are being framed as anti-Semitic for being Palestinian or for talking about Palestinian human rights in these settings. And so the power that these groups have and continue to wield was not made aware to me at all until this censure, right? And in calling for the bare minimum, they've been able to sort of weaponize these political spaces. So I think, knowing what I know now, if I knew that a year ago, I would say that it is really important, as much as it is for us to be protesting, it's also important for us to be taking up these spaces at Queen's Park or federally, like people have been doing, to participate in committees, to participate in critiquing legislation, to lobby your MPPs and your MPs, not just writing letters, but being physically present in these places of power and running for office in order to push back against the heavy lobbying that's being done. And the connections that are being made toward like the literal money that they are receiving in the middle of our education system falling apart, our healthcare system falling apart, to be able to be in our schools. As much as like the radical in me wants to be like, oh, like bun the whole process, bun electoralism, seeing what they've been able to do internally by engaging with these systems should cause us all to pause and really rely on every mechanism available to sort of push back. So that means like the legal systems, but also the electoral systems, to make sure that we're pressuring politicians to not perpetuate further harm as much as we can. I think that there have been many politicians who continue to take trips and have taken trips to Israel, to Tel Aviv, and these lobby groups, I would go as far as to say their involvement in supporting the state of Israel as it stands is, to me, what looks like foreign interference, right? And so weaponizing this language and sort of being able to call into question their ability to function here to cause harm overseas is where I think some of this legal work should focus, and where I see my role as an elected official to be able to say this shouldn't be able to exist. In terms of legal updates on the censure itself, we appealed the censure ruling, so I lost that case, and I think that I'll lose the appeal as well. I will be able to be uncensured if I'm reelected in the next cycle, so I'll be running again. But again, it shows that the solution to sort of the attacks on that level is to speak up, to stand up, but also to like do everything we can to push back in these spaces and not cede any spaces to the Zionist lobby and this rhetoric that continues to unfold. I think that there's lots of connections that can be made around policing here as it happens, and the policing tactics that are utilized by the IDF, or in the policing that's done here against encampment, this encampments run by students, but also like generalized protesters who are just out in the streets. Like the Toronto Police Services and our politicians have shown again and again that they're going to utilize the same tactics to say people are not allowed to occupy public space, especially on the question of Palestine. And so I see this fight as connected to the fight against police brutality, against the fight against Black lives that happens when we're talking about policing and the troubles there. So I see, and I think the role ahead of us is to not cede any public spaces electorally or in any of our sectors to any of these groups, and continue to figure out how we too can lobby and push back in these sorts of ways. I don't know if there's anything else that you wanted me to cover today.
I think you've said so much, and thank you for your comments. You've raised a lot of really important issues around the erosion of democratic rights, the there, and I talked about that synergy in my introduction as things move. Pro-Israel lobby groups in the Israeli state are synergetic to how Canadian colonial policies work. And in that sense, you raise the strength of the pro-Israel lobby. And my question to put out in the ether is it, should we, I hope we can question, or I want to question, why is Canada listening? Why are politicians listening? Not why are they so strong, or why do they have so much power? That's, to me, that's the wrong question. But let's focus on why is the Canadian state listening, and what interests does this serve, right? To accede to these politicians. So thank you so much. We have Dania Majid next. The indelible Dania Majid. Dania is a housing rights lawyer, co-founder and president of the Arab Canadian Lawyers Association, and is the lead author of the Arab Canadian Lawyers Association 2022 report called Anti-Palestinian Racism, Naming, Framing, and Manifestations. She's the co-founder and artistic director of the Toronto Palestine Film Festival, and she sits on the steering committee for Hearing Palestine, the Hearing Palestine program at the University of Toronto. And welcome, Dania.
Thank you for inviting me to be a part of Scholar Strike Canada. Campuses have always been the front line of pro-Palestine and social justice activism, and as a result has been a primary target of repression by pro-apartheid groups and the institutional actors who are complicit in oppression. I believe the starting point of any discussion related to repression on campuses, specifically around Palestine, must start with the acknowledgement of the roots of repression. The 76 years of Nakba, settler colonialism, apartheid, 56 years of occupation and settler violence in the occupied Palestine territory, 17 years of siege of Gaza, and 403 days of genocide, systemic extermination, orchestrated starvation, scholasticide, systemic destruction of healthcare, homes, businesses, and civilian infrastructure, including water and electricity, spread of disease, land grabs, and many other live-streamed atrocities. This genocidal conduct has now expanded to Lebanon, where we are seeing similar patterns of mass murder and destruction play out there as well. Gaza is repeatedly described as apocalyptic, and Western governments are not doing anything meaningful to stop Israel's genocide. Instead, they have expended more resources to shut us down than stop the genocide. The silencing, censorship, reprisals, and repression on campuses is an extension of and is meant to uphold the settler colonial violence in Palestine. As Palestinians and allies on campuses, the various forms of student, faculty, and union organizing, especially around BDS principles, has played an integral role in resisting the clampdown on academic freedom and campaigns on campus. And this is how the biggest gains have come, and this is how cross-sectorial and diverse allyship is formed, and how awareness is raised. And this is the way to use academic institutional processes to push institutions to take action. And this is how to acknowledge how knowledge, strategies, lessons are passed down from one group to another. And no doubt it's hard work, and strategic thinking requires or strategic planning requires understanding of past and present factors and how it might impact future conduct. It takes physical and personal resources to work together to carry out this work, but it is also a space that fosters creative thinking and learning and actions. And when you work strategically with allies and gather the information, you're able to build sustainable wins, one over the other or one on top of the other, and limit falling into demobilizing traps and minimize risks especially for vulnerable movement members. On occasion, as part of these campaigns, litigation or quasi-legal actions and tactics might be appropriate. I come from a movement lawyering background through work in the environmental movement and renter rights, and strategic litigation has been a tool of our campaign work, and has been a strategic approach that has helped us achieve some of the outcomes sought. It should be acknowledged, and I think everyone watching knows, that the Canadian court system and its laws are colonial structures. And when it comes to the legal question on Palestine, the courts usually avoid it entirely or offer negative findings. Litigation can also be very resource intensive, and it can also be demobilizing, regardless of there being a win or a loss. A lot of times non-lawyers are very frustrated by the slow pace of change, and sometimes place too much faith in legal wins resulting in change, and do not appreciate sometimes how powerful their own organizing is in gaining those wins, even though they're slow and incremental, but they are what is driving change at the higher levels or at institutional levels. And sometimes so much energy and focus is placed on a case that not much work is placed on what happens the day after the case concludes, which can take years. And this is sometimes where the demobilization takes effect. But this is not to say you don't go to court when appropriate. And there are many times where you should, especially if you're facing criminal charges or loss of employment, and as well as when it is tactical. And there may be an opportunity to support a campaign or respond to a situation to protect Palestinian rights or raise the Palestinian narrative. But even doing so, there are risks that should be accounted for, and that includes creating bad precedent, and again, ensuring those who are affected are not put at unknown risks, or again, it negatively impacting a momentum of a campaign. Because no matter what happens, the organizing work must continue. One recent case that I will talk about, it also illustrates some of these points. And it was the ACLA's involvement in the International Human Rights Program dehiring scandal at the University of Toronto Law faculty. This case was outrageous, but it was also an opportunity because for the first time we had actual verification of a person losing a job opportunity because their position on Palestine, Israel. And up to this point, it was really something that we carried internally as people who felt gaslit or paranoid that this was happening to them, and we had brave faculty in the Faculty of Law who really blew the whistle on this and, drew our attention to what was going on. And we decided to get involved at the very beginning because we did not want Palestine to be erased from the narrative and it only becoming, a discussion around donor interference and academic freedom. We knew Palestine was at the core, and we got involved because we wanted to make sure it remained at the core of this scandal. For our community, who we heard from, and this included many academics and law students and legal professionals, they wanted us to make sure we named what was happening at U of T. And so we started using the term anti-Palestinian racism to keep the scandal focused on academic freedom on Palestine. Soon after, we had the Center U of T campaign, which was a very successfully run campaign to pressure the university to rehire Dr. Azarova. So we, made sure, us and our allies made sure that Palestine remained front and center. And we then did our own adjacent work to hold Justice Spiro accountable, because the U of T, Center U of T was academic base. We wanted to make sure that we got some accountability from the judge who interfered in the hiring. So we filed a complaint with the Canadian Judicial Council. And then when we received their decision, which excused his conduct by claiming he wasn't Islamophobic because he had Muslim friends and did not address our arguments around anti-Palestinian racism, we decided to judicially review the decision. And we weighed the risks of a bad precedent before proceeding. The cons were known. We know the federal court is hostile to our community. However, for us, what outweighed that was strategic pros. And that was for us to go into court to, argue and raise anti-Palestinian racism and force the other side to also raise it and defend themselves from it. we also wanted to maybe, as a bonus, get maybe some positive language around the phrase, the term. And at the time, it was very much very new terminology. So it had not had broad societal acceptance at that point. So it was important for us to get that terminology out there. And because this was such a scandalous case, we knew we would get more media coverage if we did go to court, and opportunities to talk about anti-Palestinian racism in mainstream media. We also got very valuable disclosure that validated what we knew about academic freedom on Palestine and the censorship that happened. So this was also very educational for us in terms of how do we address APR on campuses. And it was also an opportunity to educate the courts and the clerks and whoever read our materials and heard our submissions. At the end of the day, it was the Censure U of T campaign that got Dr. Azarova her job offer. But the legal work allowed us to discuss anti-Palestinian more broadly, and it eventually led us to writing our 2022 ACLA anti-Palestinian report that has been used by those who are most directly impacted in their organizing, in their local context. And it's that grassroots organizing through that report that has gotten APR recognized, and it hasn't really come from the courts, even though the courts have since addressed it. We briefly, if I have a couple more seconds, we did raise APR in our intervention at the U of T encampment case. And this meant the students and the university were already going to court on this case. And the ACLA intervened in order to bring the Palestinian perspective in that case. So what we wanted to do was demonstrate how the allegations against the students, the grounds that were being used against the students, were based on anti-Palestinian racism, by educating the court on what is anti-Palestinian racism and what were the true meanings of some of the phrases that were deemed anti-Semitic against the students. We knew the university or the courts would likely find in favor of the university. However, the win here was we actually got a really strong decision around anti-Palestinian racism, and that we knew by getting that language into a court decision that this would be helpful for other encampment cases. And what we did see in the other interventions we did end up getting involved in, those universities learned and instead, stopped or did not use anti-Palestinian racism as the basis to remove their students. They relied on other problematic grounds. But nonetheless, we did intervene, which was, to make sure that narrative was there, that we continued to educate the courts, the judges, around the manifestation of anti-Palestinian racism. And the benefit of an intervention is doing just that. It's a less resource-intensive process that allows us to counter the, pro-genocide, pro-Israel narrative. And this is why we got in there to challenge that. And in the U of T encampment case, none of those narratives actually were accepted by the court. And it was less resource intensive at the end of the day. So, we followed the lead of the students, their arguments, we consulted with them, and made sure we had arguments that reflected what was happening at the university level. So I will end it there because I think my 10 minutes is up. But yeah, happy to answer any questions that may come up.
Thank you so much. And I see actually threads between what you've just talked about and what Sarah talked about, in the sense that you've both engaged in litigation, strategic litigation, and it has not actually demobilized a movement, right? There are instances where the litigation actually has amplified many dynamics in the movement and brought them before the courts to be faced head on. And the work that you're talking about, the mobilization has continued from Censure U of T and the Azarova and the work of ACLA. We see that those networks have been in place and continue to be in place and are mobilizing at this moment continually. So thank you so much, Dania. And next we have Rochelle Friesen. Rochelle is a powerful advocate, and she organizes with the Toronto Legal Support Committee. The committee formed in October 2023 and has been supporting folks who are arrested for supporting Palestine. Rochelle also works with community peacemaker teams doing unarmed civilian accompaniment and Indigenous solidarity. She previously spent 5 years living in Palestine working with a humanitarian aid organization. So welcome, Rochelle.
Thank you so much for having me. It's great to be invited to speak on this panel. For my portion, I will be speaking about how lawfare is experienced on the ground this past year, highlighting people's first interaction with the law here, and that is the tactics and trends of the Toronto Police across the city. TPS is one arm of the state that is exacting state oppression to slow down and criminalize those trying to stop a genocide. We are experiencing this severe repression because, broadly speaking, Palestine is the moral litmus test for the world. And here on Turtle Island, the fight to stop this genocide has brought together masses of people from all sectors. It has mobilized post-secondary students, unions, professionals, healthcare workers, lawyers, artists, writers, and parents of various school boards, just to name a few. Yet if we are collectively fighting for an end to the settler colonial project's violence in Palestine, it does bring up questions of what does that mean for so-called Canada, its institutions, and its ongoing genocide of Indigenous people here. So this is why we are under attack. The harm the state is trying to inflict through TPS is multifaceted. Physically through beatings, psychologically through surveillance and harassment, and materially through criminalization that also leads to doxing by a vigilante mob. In a severe case, one arrestee's home address was posted online. And while media should be the voice of accountability, they have been the voice of the armed forces of state, and I will walk you through what that has looked like. The Legal Support Committee, through our work, we have been in contact with everyone who has been facing charges. If we are not directly in contact with the individual, we do make contact with the family. And the support that we have provided for arrestees has been community support, legal support, and materially through the Toronto Community Justice Fund, which everyone should donate to. We know the state's tactic is to take our community and try to divide it up into individuals, isolating people and their experiences from each other. And by design, the court process exasperates this. So the work of the Legal Support Committee is to ensure that our community and our collective remains strong so that no person is left behind. The first arrest that took place since October 2023 was on October 30th when 13 people were arrested and given trespass tickets. Since October 30th, TPS has arrested and charged 97 people. Some of them have been charged twice for different events, and some of them have multiple charges for the same event. People who have been charged have had release conditions ranging from protest bans, non-association, and a restriction of being 500 meters away from specific sites of protest. At times, an individual may have multiple conditions placed on them. Over the last year, we have also seen a change in tactics in how the state criminalizes us. Well, on October 30th, 13 people were arrested and given trespass notices. Since then, the charges have escalated. From November until August, the majority of charges were various forms of mischief. But since August of this year, we have seen a shift to charge people with assault of a cop, probably because TPS wants a victim narrative. We haven't figured that one out yet. In addition, from October to January, the majority of arrests were happening on site. And it is in January 2024 where we start to see an increase in phone calls and door knocks from TPS inviting people to turn themselves in, often without an arrest warrant and for actions that happened months prior. The trends that we have seen are before suspected weeks of action, there is an increase in door knocks, phone calls, intimidations, and arrests. For example, before April 15th, when there was a global call for escalation, TPS arrested 3 people for actions that took place in January. Prior to the U of T encampment being set up, there were 3 phone calls that week for turn-ins for 3 separate actions that had occurred months prior. And before there was a perceived escalation at the encampment, a search warrant was conducted on someone's home, seizing articles of clothing, including nefarious materials such as a vest, shoes, a purse, and of course, a keffiyeh. As the Legal Support Committee, we suspected that we were going to get swoops at the end of September and early October. And from September 11th until October 7th, we had 14 arrests. More than 10 people have had their homes searched. TPS has seized things like kafiyas, electronics, clothes, and have ransacked their homes. These searches are a way for TPS to show force. They're a way to do surveillance. And it's also a way to try and send shockwaves through a movement as a whole and try and force it into submission. All of the above tactics comes with harassment and surveillance from the state. TPS has followed people home after protests. At protests, uniformed officers have wandered into crowds, taking pictures of individuals. They have yelled out individuals' names as an intimidation tactic. But this harassment continues outside of protest sites. TPS has parked outside of people's homes. People have been harassed by cops yelling at them as they go about their regular daily lives. People have even been followed in parks as they're going for a walk. These arrests have all been categorized under the hate crimes unit, regardless of the details of the arrest. Every single pro-Palestine arrest is investigated by the hate crimes unit, and many times TPS will write a press release announcing the name of the person, their charges, and that they are being investigated for a hate crime. Meanwhile, they have used all of these charges and these arrests as a way to create a case to increase their budget and to show that they're being effective, when in reality, a good chunk of these charges have not been held up in court and are in the process of being withdrawn. So while TPS writes press releases and manipulates the narrative, we do not have an independent media to report on these criminalizations. Since the Land Day press conference that saw TPS put on their heels, mainstream media has effectively chosen to ignore the movement and rather regurgitate TPS press releases, even if they are factually incorrect or a manipulation of the truth. For example, in the TPS October 7th presser, Chief Demke said that someone was arrested at the airport with outstanding warrants while trying to leave the country. Well, factually, this is technically true. They did leave out key information, though, to manipulate the narrative. This person was headed to the US for 48 hours with full intention of returning and also had no knowledge of the arrest warrants. CTV, having read the TPS release, then published that that individual was actually trying to flee the country. Despite us putting out a press release with media spokes contact where we were correcting the false narratives made by Demke, media did not reach out to us or correct their coverage. This has been the consistent practice of the media since March. Arrestees have provided press conferences and press releases that fact-check what the police are saying, and while getting no contact or no coverage from mainstream media, TPS will publish a press release about individuals that have been arrested for tagging or doing graffiti, and somehow mainstream media will consider that newsworthy to be published. On September 11th at 51 Division, we saw one of the most brutal police beatings since the Landport Stadium encampment clearing of 2021. It received no media coverage until, that is, when TPS mentioned that some cops received minor injuries and then called for multiple arrests. In contrast, that day we had 8 people go to hospital for serious injuries, including torn ligaments, concussions, and bruised ribs. Again, this was not reported by mainstream media. Gratefully, The Grind was able to cover the story. At this time, mainstream media outlets are assisting armed state actors in manufacturing a narrative that enables the brutalization of pro-Palestine activists. Well, I've touched on how TPS is criminalizing the movement. It's also important to touch on their tactics and practices at downtown protests and rallies. These protests are attended at times by hundreds of cops, including paramedics and fire department in full riot gear. And there are many undercover and plainclothes cops that are sprinkled throughout the protest. They are surveilling the crowd, and in specific cases, we have seen video footage and spoken to a number of people who can corroborate that police have instigated the violence, such as the case of Land Day. Every protest has an entourage of bike cops that accompany the march. Most of these cops come from 51, 52, or 14 Division. After a year of protests, these cops have become very familiar to marshals and vice versa, and the cops' harassment and violence has become quite personal. Marshals have frequently been hit or tripped by bike tires along the route. They have been harassed based on their appearance and have received subtle threats, including the offer for marshals to see the dark side of policing, whatever that means. How the police move and pivot at these marches is part of a coordinated plan. In Leslie Wood's book, Crisis and Control, she writes about the militarization of protests and policing from the years 1995 to 2003, but these tactics are still in use today, specifically strategic incapacitation and spatial control. Strategic incapacitation is when the police target one small element of a protest for enforcement. We have seen this through their tactics of our trucks at protests. For example, for years, protests have always had a truck with speaker systems with people on the truck. And yet in 2024, the truck became TPS's target to regulate through an obscure bylaw rule. So now that no one can be on the truck and it must be inspected. And while this seems like an obnoxious annoyance, in reality, the police have been using this as a way to gain access to our crowd, gauge who the organizers are, and check out the discipline and the vibe of the protests. We have seen that when there is no truck present, they focus on the speakers, making this a means that they can control and gain access to our spaces. This is now also a tactic that is being used not just for Palestine, but for all marches. They used it for the Grassy Narrows River Run and the Migrants' Right Action as well. The other main tactic TPS employs through their incredible numbers at our actions is spatial control. Frequently, TPS has created no protest zones or routes, which change week by week. An example of this is an attempt both to control space, but also to enforce submission of a protest. Some weeks, the protest can't go south of Wellington. Other times, it's forbidden to go north of College. Other weeks, going to the US consulate has been deemed out of the question. TPS is actively practicing containment, and when protesters have pushed back, they have been arrested or brutally beaten. With criminalizations and violence, TPS is trying to ensure maximum amount of chaos and fear spreads through the community and the movement in hopes that people are scared into submission. Not only is TPS regularly and intentionally violating people's charter-protected rights, they are doing so in coordination with policing services across the country and federally through Project Resolute. All the tactics being employed against the Palestine movement right now will in time be used against any movement that challenges the state, capital, and the status quo. Despite the repression and extensive policing, we understand the stakes are high. We have not been deterred, and we will not stop. We are committed to ending the genocide and the Canadian complicity. We will not be silenced, and we will not back down. And I have lots more to say, but there hopefully will be time for questions later.
Thank you, Rochelle, such detail about the last little while of criminalization, and I want to connect what you said to some points that Sarah made about the strength of the pro-Israel lobby group. But I'm going to question in whose interests this kind of policing, these decisions are made. So we know that many of the calls for increased funding to police and resources and criminalization are definitely emanating from pro-Israel lobby groups. However, why is the state so quick to heed those calls, right? Because it's very much in the interests of the Canadian state and the settler colonial legal system to say, oh yes, well, of course, this is what we do. This is what we've been doing for hundreds of years, and it's well within our worldview to heed those calls. So thank you so much for highlighting the details of the criminalization of dissent in this time. We have next Joshua Seeley Harrington, who is now my colleague at the University of Windsor Faculty of Law. He's an associate professor in the chair of equality law at the University of Windsor. Before joining Windsor Law, Joshua was an assistant professor at the Lincoln Alexander School of Law, where he won awards for his steadfast defense of academic and Palestinian freedom. Joshua's research and advocacy apply critical legal theory to questions of socio-legal identity and justice, with a particular focus on Black and Palestinian solidarity and resistance. So welcome, Joshua.
It is both a privilege and a tragedy to be on a panel with such wonderful comrades discussing lawfare in the context of anti-Palestinian racism. It's a privilege, given the immense respect I have for each of you in fighting for Palestinian liberation. But it's a tragedy given how distracting all of this reprisal is from what should be everyone's core task, which is ending the genocide in Gaza and liberating the Palestinian people from Israeli apartheid. As Toni Morrison explains, the very serious function of racism is distraction. It keeps you from doing your work, and it keeps you explaining over and over again your reason for being. And I can't help but feel like I am caught in this infinite loop of explanation every time I speak on a panel relating to domestic reprisal on Palestine. And yet we must persevere, we must organize, and we must fight. And so I remain so honored to be here and to be part of the struggle with all of you. The title of this panel, Lawfare, Strategies and Lessons Learned, deeply resonates with me as someone who existed at the epicenter of academic reprisal over the past year, and who considers it essential for us to extract insights from that reprisal. The left is very good at counting losses, but we can sometimes neglect to count victories. And what happened at TMU Law this past year was in so many ways a monumental victory from which we can learn and mobilize. I'll first provide brief context on what happened at TMU and then discuss the reprisal that occurred to illustrate what lessons I think we can take from it. But I'll lead with the punchline, which is that I think it is essential for student organizers to fight, meet resistance, and then escalate for the liberation of Palestine. In context of TMU Law, students were absurdly investigated for potential expulsion because they wrote a letter. Students who we teach about the importance of written words being subject to a specious anti-Semitism inquisition for daring to use those words for justice. But they were not expelled. They were not even formally slapped on the wrist. They were, in relation to the formal grounds of investigation against them, completely exonerated. Universities who intimidate their students, I think, want to set a ceiling on their advocacy. But with this exoneration, it is just the opposite. The students' exoneration sets a basement. They have license to write radically about Palestinian liberation, and yes, to defend Palestinian resistance, and they should exercise that license. Because while these students were investigated over the course of the past year, the Lancet estimates that approximately 200,000 Palestinians have been killed in Gaza. I'm so proud of these students and of their steadfastness, but we need to keep our eyes on the prize, and that prize is a free Palestine in our lifetime. So let's begin with some context. On October 20th, approximately 1/6 of the TMU Law student body signed a petition critiquing the administration's shameful neutrality in the context of what leading Israeli scholars had already described as a textbook case of genocide in Gaza. The students wrote a petition to the dean that included 2 passages which enraged many Zionists. First, that Israel is not a country, but a brand of settler colony. I note parenthetically that the petition also called so-called Canada a settler colony, and in any case, Israel is indeed a settler colony. Second, supporting all forms of Palestinian resistance, including, of course, armed resistance, which is a human right under international law, and the necessity of which is surely apparent after a year of live-streamed genocide. Now, I want to be very clear about something. I just made 2 parenthetical references implicitly defending the students' petition. For example, the students also calling Canada a settler colony, and that armed resistance is a human right. But these references are, I must emphasize, excessive, not necessary to legitimate academic expression. Academic freedom in the university, of course, permits being incorrect. If a student called a country a settler colony and it wasn't one, that is not grounds for expulsion. It's an opportunity for education. Full stop. Academic freedom in the university also, of course, permits challenging the law. Legitimate free speech is not limited to agreement with existing laws. TMU itself marketed on educating lawyers who would challenge the status quo. By necessary corollary, then, students are not only permitted, but at times actively encouraged to challenge existing laws and legal frameworks. I say these parentheticals, though, to illustrate the absurdity of this particular case. For accurately describing Israel and for affirming Palestinian human rights, 1/6 of the student body at TMU Law were subject to a 6-month investigation with the threat of potential expulsion. This is what we mean when we say there is a Palestine exception in the university. To be blunt, my focus today is not on whether anyone agrees with the content or tone of the students' petition, Both, of course, can be subject to vigorous debate. But if you think that formal sanction should even be entertained in the context of such a statement and the ongoing genocide in Gaza, you are not simply an enemy to Palestinian liberation. You are further an enemy to the academic freedom that is essential to our crumbling democratic order. With that context addressed, let's consider the reprisal confronted by the students. There are two forms of reprisal that TMU law students confronted, formal and informal. And with respect to formal reprisal, I will focus on the academic reprisal they experienced. With respect to academic reprisal, I'm more specifically focusing on the investigation that they experienced for potential expulsion under university policy. 3 days after the students sent their petition, and after what was surely a weekend of myriad communications from various Zionist donors demanding retribution against the students who were simply answering the call for racial justice that TMU itself marketed, the dean released a public statement defaming the students as anti-Semitic terror supporters. And within a month, the university launched a formal investigation against the students. According to the external reviewer appointed by the university to investigate the students, quote, the ultimate substantive issue for the external review of the reviewer was to decide whether there had been a breach of community standards. And he made 3 key findings. First, that none of the students who participated in the letter were found to have breached the code. Second, that the petition was a valid exercise of student expression. And third, that the administration perpetuated harm by publicly condemning the letter without first giving the participating students a meaningful opportunity to explain themselves, or without first even seemingly settling on a definition of anti-Semitism or applying that definition to the contents of their petition. I'm going to outline the external reviewer's analysis now, but I want to pause here to stress how significant these findings are. After 6 months of investigation and after being defamed by their own dean, these students were not simply exonerated. The dean herself was criticized for rushing to judgment against the students. This is a monumental victory for student activism. And as noted, this should set a basement, not a ceiling, for future student mobilization for Palestine. Now, the reviewer relied heavily on certain key concepts in his analysis, namely how academic freedom and free expression are central to the concept of the university. With academic freedom, I note, marshalling the political leverage of faculty associations across Canada, a crucial political tool for students to strategically deploy. This is important. As a critical legal scholar, I am, of course, skeptical about the certainty of legal advocacy. But universities are first and foremost spaces of critical and unorthodox inquiry. Consequently, legal scrutiny of administrative reprisal against Palestine solidarity threatens not just the competence of these reckless administrations, it also threatens their credibility. When donors demand that students be expelled for political expression, and when administrators shortly after those demands are made investigate students, such reprisal is, of course, racist, but it also calls into question whether these students are even attending a university in the first place. Now, I'll briefly outline the reviewer's key analysis, which illustrates the massive abyss between how mainstream media and legal institutions discuss student activism for Palestine. First, threats of violence. The students were called literal terrorists in mainstream media for defending Palestinian human rights. What did the reviewer find? Quote, the respondent students did not commit any acts of violence or threaten violence, nor does the letter itself threaten violence. Pretty straightforward. Second, disrupting the university operation. The students were routinely blamed for what the dean repeatedly called an existential crisis at the law school. What did the reviewer find? Quote, the respondent students' participation in the letter had the unfortunate result of disrupting the law school experience, but not in a manner that would constitute disrupting university operations that would qualify as a breach. I would note that the real source of disruption was the university's reprisal, not the students' petition, but still, the reviewer found no breach. Third, pro-Palestinian advocacy is routinely mischaracterized as hate speech. What did the reviewer find? Their participation did not rise to the level of breaching the law. The types of conduct listed in the code, possessing weapons, selling illegal drugs, etc., also constitute offenses under the criminal code. Here, there's no allegation and no indication whatsoever that the respondent students committed a criminal offense. It is genuinely unfathomable to me that accurate legal description and affirming human rights is being perverted into supposed hate, when, if anything, it is immense love that animates the movement for Palestinian freedom. Fourth and finally, Zionists argued that pro-Palestinian expression is somehow inherently harassing. Some Jewish Red Zionist students may feel subjectively harassed by pro-Palestinian expression, akin to how just yesterday people claimed that Jewish Red Zionist students were subjectively harassed by the fact that an Arabic song was sung at a Remembrance Day ceremony. But feelings are not facts, and they are certainly not law. What did the reviewer find? He found no harassment for two interrelated reasons. Jillian, can I have like another minute? Is that okay? Yeah. First, he found no harassment because harassment must be interpreted in light of academic freedom, which is true. But second, he found no harassment because the students did not intend to harass Jewish Red Zionist students, which is an analysis I consider woefully incomplete. The key here is that accurate description of Israel and support for human rights, no matter how subjectively distressing to anyone, cannot fathomably qualify as harassment. Objectively speaking, the students' petition was legitimate speech, full stop. Indeed, whereas Zionist organizations condemned the letter as anti-Semitic, anti-Zionist Jewish organizations, like Independent Jewish Voices, defended the students' right to free expression and rather condemned the reprisal the students were experiencing, which makes two essential points about anti-Semitism and academic freedom. Regarding anti-Semitism, if Zionist Jewish organizations consider something anti-Semitic while anti-Zionist Jewish organizations do not, the material issue, clearly, is not anti-Semitism, but anti-Zionism. No wonder Zionists relentlessly seek to collapse the two. And regarding academic freedom, given that there is immense scholarly and political debate within the Jewish community itself about whether such expression is anti-Semitic, to consider that expression outside the scope of legitimate inquiry is to consider intra-Jewish debate outside the scope of the university. Worse, it silences anti-Zionist Jewish expression within the university, which I would note is actually anti-Semitic. I'll conclude by saying that the TMU students released one of the most radical defenses of Palestinian liberation in North America and received no formal institutional academic sanction for that advocacy. This is a tremendous victory for pro-Palestinian expression, and I would encourage student organizers to understand the basement, not ceiling, the steps for their future written advocacy. As a critical left scholar, I am more than most skeptical of using legal tools for racial justice, but the right is very interested in attacking academic freedom and universities precisely because they construct an unusual space where the power of elite interests is at least partially qualified by the character that universities supposedly hold dear. Universities are consequently unique spaces for critical inquiry, and it is essential that we leverage that space for racial justice. Indeed, that's the very spirit of Scholars Strike Canada, which I'm so honored to be a part of today. Thank you.
Thank you so much, Joshua. And it really is inspiring to hear. I'm not unaware of the issue at TMU nor the report, but to hear it all put into 10 minutes of inspiring, like this is a real win here is really heartwarming, especially for many of us. I know you as well. Thought of the initial investigation and report as an instance in itself of anti-Palestinian racism, but for it to come out in the ways that you've outlined is really something that we all rely on still, which relies on your work, Dania, previously with the anti-Palestinian racism report, you know, and so on. So wonderful to see the threads of the activism through legal processes being successful in so many ways. So we're down to our last speaker, my friend and colleague, Shane Martinez, who is a Toronto-based criminal defense lawyer and human rights lawyer at Martinez Law Professional Corporation. Shane litigated the first private prosecution of Israeli military recruitment in Canada and has pursued complaints to the Canada Revenue Agency regarding the funneling of charitable donations to the Israeli military. He defends people who are criminalized because of their participation in Palestine solidarity protests. And in 2024, he represented Independent Jewish Voices, the Jewish Faculty Network, and the Arab Canadian Lawyers Association. I'll say in our joint intervention in the case of Sarah Jama. So there's some synergy between his work on that case and the panelists that we have here today, including myself. So welcome, Shane.
Thanks so much, Jillian. And it's great to kind of be alongside phenomenal co-panelists today speaking on this. I guess for my remarks, I'd like us to consider today how the Canadian state tries to maintain a monopoly over different types of law, criminal, humanitarian, regulatory law, and how it tries to use its control to protect Israel's interests and also repress the Palestine solidarity movement. But I'd also like us to consider how the people are attempting to use these same legal frameworks to pursue state accountability and build strength in the movement for a free Palestine. So this kind of requires us to look at, what do we mean by this monopoly over the law? We're talking about Canada's attempt to have exclusive control and exercise over when and how the law is either being used or is not being used. And for the purpose of our discussion today, I want to look at three examples of how Canada maintains these violent realities for Palestinians through both its use of the law, but also on its restriction of the law being used and restricting people from having access to the law. And for each example, I'm going to show not only how the state is doing that, but also how people are pushing back and creatively trying to use these same legal frameworks. So for the first example, we can look to the Genocide Convention, which Canada ratified back in 1952. Now, because this is customary international law, it's automatically adopted into the Canadian common law. And Canada, as a contracting party to the Genocide Convention, has an obligation to prevent the crime of genocide from occurring. What's required is that when there's reasonable grounds to believe that a genocide might be occurring or might occur, and where that situation is within Canada's sphere of influence, Canada has an obligation to take effective measures to prevent genocide to the extent that it can within its capabilities. However, what we've seen over the last year is Canada refusing to take any meaningful diplomatic, economic, or military action to exert influence over Israel in an attempt to stop the genocide in Gaza. But beyond not taking any reasonable measures to prevent genocide, Canada has also been actively supporting Israel's military capabilities, which I'll hit on momentarily. Now, in February of 2020, Canada even lobbied the ICC prosecutor's office in an attempt to prevent an investigation of Israel's alleged war crimes and crimes against humanity. And this is despite the fact that we have incorporated into our own law here the War Crimes and Crimes Against Humanity Act, which provides for the punishment of those found guilty of war crimes, crimes against humanity, genocide. But Canada gatekeeps enforcement of the act. Section 9 basically says that proceedings for these offenses of, again, genocide, war crimes, and crimes against humanity, those cannot be prosecuted without the personal consent in writing of the Attorney General or Deputy AG, and that proceedings can only be conducted by the AG or counsel acting on their behalf. Now, curiously, the lobbying of the prosecutor's office at the ICC that I mentioned a moment ago, that actually appears that may have been an offense under the Act. Section 16 of the Act says that any person who willfully attempts in any manner to obstruct, pervert, or defeat the course of justice at the ICC is guilty of an indictable offense. But again, it kind of seems that's exactly what Canada did when it was interfering on Israel's behalf. But this is the contradictory reality that we contend with when the state exercises such a monopoly over the use and control of the law. Now, although the people themselves can't directly hold perpetrators of genocide accountable in Canada under the Act, and although the people themselves don't have standing to commence proceedings at the ICC, there's still some creativity in finding ways to hold Canada accountable for its failure to hold Israel accountable and to prevent Israel from committing genocide. And we saw that last Wednesday when the Coalition for Canadian Accountability in Gaza announced a lawsuit against the federal government on behalf of two Palestinian Canadians. And one of them was in Gaza in October 2023 when Israel began its bombardment, and the other one was trying to have his family brought over here for to seek refuge. And the lawsuit, it weaves the duty to prevent genocide with sections 7 and 15 of the Charter, and essentially alleges that Canada's refusal to uphold the rule of law where Israel's armed forces are concerned, and Canada's bolstering of Israel's military capabilities had an adverse impact on the plaintiffs and causally contributed to violations of their rights under those sections of the Charter. In the interest of time, I won't get into the details too much of that case, but turn now to maybe a second example, which is the Arms Trade Treaty. Again, Canada's a party to it. Canada also has its own legislation which kind of adapts the Arms Trade Treaty, which is the Export Import Permits Act. And that prohibits arms transfers if there's knowledge that they would be used in the commission of a war crime. But what we know is that over the last year, Canada's permitted record shipments of arms and other military technology to Israel, particularly in those first 3 months of Israel's bombardment of Gaza. Record amount of exports from Canada to Israel. And in response to massive pressure from protests, Canada tried to obfuscate by passing this non-binding motion to pause new export permit approvals. However, what we know is that numerous existing permits remain valid, that there's over 200 valid permits to ship to Israel right now that have expiry dates as late as December 31st of 2025. We also know that Canada continues to allow the United States to receive arms shipments as an intermediary and then ship them on to Israel. So to push back against the hollow kind of non-commitment loopholes that the state latches onto, Canadian Lawyers for International Human Rights began an application in federal court in March of this year in an attempt to force the government to stop arms exports to Israel. And the applicants in that case are seeking an order that the government cease issuing export permits for all military goods and technology destined for Israel, and that the issuing of these permits be declared unlawful under Canadian international law. So again, kind of this novel use of the law to push back and to force the state to take action that it's refusing to do. There's a third example as well, which we can look at, which is the Foreign Enlistment Act. This is another example of Canada, I think, restraining the use of the criminal law where Israel is concerned. Section 11, sub 1 of the Foreign Enlistment Act says that it's a criminal offense for any person in Canada to recruit or otherwise induce someone to enlist or to accept any commission or engagement in the armed forces of a foreign state. But Canada refuses to take enforcement action against organizations which openly recruit here for Israel's military, and have been doing so over the last year as well. It's trying to seek volunteers for Israel's war effort, they say. Now, you can imagine how Canada would react if there was an organization in Canada recruiting volunteers for volunteer engagements in Russia, North Korea, China, Iran, and so on. But despite there being complaints being made to the police, parliamentary petitions, this being drawn to the state's attention and them acknowledging it as well, there's been no action whatsoever to halt these open recruitment efforts and seemingly blatant violations of the Foreign Enlistment Act. And when 2 Canadian citizens stepped up to try and do something about it, Rabbi David Meviser and Palestinian artist Dr. Rahab Nazal, they were successful in showing the court that there was evidence on all elements of the offense against one of these organizations that was responsible for allegedly recruiting volunteers to join IOF efforts over there. Now, what ended up happening is that a criminal charge was laid against this organization that was recruiting volunteers for the Israeli military, and the matter proceeded in court. What did the state do? Well, the state intervened. They shut the case down. They took it over. The Public Prosecution Service of Canada came in, they took the case over, and they shut it down before it could ever reach trial. Now, what ended up happening is that Rabbi Meviser and Dr. Nazal, they're continuing to pursue that matter at appellate levels. And now the case is actually alleging that Canada's intervention and termination of the prosecution was an abusive process, and that it was part of a larger pattern of trying to insulate Israel's armed forces from the rule of law. And it was heard last week in the Court of Appeal and is presently awaiting a decision. So to wrap up, what I'll say is that, I'm mentioning these cases not under some sort of an illusion of what the law can achieve, but rather as examples of how people can push back within these same legal frameworks that are oftentimes used to restrain or repress people. And that the state typically structures the law in a way to insulate its interests and the interests of its backers and its allies. But there are ways in which engagement in legal processes does serve this truth-seeking function about the state, regardless even sometimes of how the litigation turns out. It reveals the limitations and the possibilities of the law as a tool for social change, and it provides opportunities, I think, to lift the veil on precisely how the state does what it does and the role that the law and legal systems play in that. And this is essential to political education within mass movements. And I think we can find important wins in that, no matter what direction these cases go in. So yeah, thank you very much.
Thank you so much, Shane, and for all of your legal work in so many different kinds of cases that are really crucially important. Some of what you're saying highlights, we talk about the Palestine exception, academic freedom except for Palestine, rights except for Palestine. But what you're highlighting is the Israel exception, accountability except for Israel, and these truth-seeking functions of the litigation, I hope, will expose some of those truths. Well, I want to thank all of you brilliant panelists for sharing your time and your knowledge and your experiences and your expertise on lawfare strategies and lessons learned. I'm sort of left with reeling with inspiration and thoughts and um, 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 and your brilliance. Just a note that I think that there might be a technical issue with the link for the upcoming pre-recorded poetry session that's on our schedule. So maybe stay tuned and hopefully it will work out. I think one of the big questions that I'm left with, which has been on my mind for a long time, all of your talks really highlight, of course, the repression of Palestine solidarity and the ways that law is being used to silence, to recreate laws in their own images, that further sort of settler colonial goals. Really, it calls into question the whole legitimacy of Western liberal democratic rights. And, I often find myself asking if we have to fight so hard for basic rights, doesn't that tell us something about the system that sort of bestows those rights or is supposed to bestow those rights? Thank you so much to the organizers of Scholar Strike once again, and the folks in Acadia who are occupying spaces to listen to Scholar Strike. Thank you to the panelists, and I'll leave you with a thought that was brought up by Joshua, which is that I leave you with immense love as being the motivation for our work towards the liberation of Palestine, free Palestine. And thanks everyone so much.